Welcome back to Piercing the Corporate Veil, Lessons from the Docket. I'm Professor Seth C. Oranburg, and as a reminder, in Episode 1, we explored the fundamental purpose of limited liability through cases like Walkowski v. Carlton and Becker v. Interstate Properties. Episode 2 examined the specific tests courts apply, including the unity of interest analysis in Sea Land Services v. PepperSource and the complex control relationship in Wallace v. Wood. Today in Episode 3, we shift our focus to limited liability companies. While LLCs share the basic goal of protecting owners from personal liability, they have some key distinctions and operate under different statutory frameworks that face unique vulnerabilities that we need to understand. We'll see how the same principles we discussed, like undercapitalization and the failure to maintain separateness, apply to LLCs, but with some important twists that make LLC veil piercing both similar and different from the corporate case. These adaptations will connect forward to reverse and horizontal piercing in Episode 4 and 5. The story that anchors today's episode comes from Wyoming, and it represents a landmark moment in LLC law. It's the case that definitively established that LLC veils can be pierced just like corporate veils, and it set the stage for how courts across the country now approach these disputes. So let's dive in to the facts of Kaycee Land Livestock v. Flahive, decided by the Wyoming Supreme Court in 2002. Kaycee Land Livestock was a Wyoming partnership that owned land in Johnson County, which is a region where oil and gas activity is common. They entered into a surface use agreement with Flahive Oil and Gas LLC, which allowed the LLC to use the surface of Kaycee's property for oil and gas operations. This seemed like a straightforward commercial arrangement, a landowner granting surface rights to an energy company for mineral extraction. This is the kind of deal that happens regularly in Wyoming's energy sector. But the situation quickly went wrong. Flahive's oil and gas operations allegedly caused environmental contamination to Kaycee's property. The contamination affected the land's value and created a cleanup obligation, turning what should have been a profitable arrangement into a costly problem. When Kaycee looked into recovering damages for this contamination, they discovered a major obstacle. Flahive Oil and Gas LLC had no assets. The company was essentially a shell. It was unable to compensate Kaycee for the environmental damage it had caused. This led Kaycee to investigate the structure behind the LLC. Roger Flahive was the managing member of Flahive Oil and Gas at all relevant times. He had complete control over all the company's operations and decisions. There were no other members to provide any oversight or share any responsibility. With the LLC unable to pay for the contamination, Kaycee made a strategic decision to sue Roger Flahive personally, seeking to pierce the LLC veil and hold him individually liable for the environmental damage his company had caused. Here's what makes this case particularly significant. There was no allegation of fraud. Unlike some of the corporate veil-piercing cases we've seen, where owners actively deceived creditors or engaged in deliberate misconduct, Kaycee didn't allege that Flahive had acted fraudulently. They were simply arguing that LLC structure shouldn't protect Flahive from personal liability for the environmental contamination his company had caused. This absence of fraud allegation made the case a pure test of whether LLC protection could be overcome based on the same equitable principles that apply to corporations. And it created a legal puzzle that the trial court felt needed resolution at the state's highest level. Wyoming's LLC statute didn't explicitly address whether veil piercing was available as a remedy against LLC members, and the courts hadn't yet established clear precedent on the issue. The statutory framework provided basic liability protection, but was silent on any exceptions. So the district court certified a question to the Wyoming Supreme Court, asking whether the LLC's veil could be pierced in the same manner as a corporate veil, even without allegations of fraud. The Wyoming Supreme Court's answer was clear and groundbreaking. Yes, LLC veils can be pierced, using the same principles that apply to corporations. The court reasoned that both corporations and LLCs serve the same basic function. They limit personal liability to encourage economic development and business formation. But when these entities aren't operated as truly separate entities, individuals don't merit shielding from liability just because they chose the LLC form instead of incorporating. The ruling was groundbreaking because it established that LLCs don't get special protection from veil piercing just because they're a newer or more flexible business form. The equitable principles that courts use to police corporate abuse apply equally to LLC abuse. The court specifically referred to the Uniform Limited Liability Company Act, Section 304, which provides that members and managers aren't personally liable for LLC debts solely by reason of being members or managers. But the court made clear that this statutory protection isn't absolute when the LLC structure is abused. The court in Kaycee remanded the case for further proceedings, instructing the trial court to apply corporate piercing factors adapted for LLCs. This included examining undercapitalization, examining failure to follow formalities, examining commingling of funds, and examining general misuse of the entity. This remand emphasized that courts should consider LLC characteristics, placing less weight on formalities that aren't required for LLCs, while focusing more on the truth, the reality of overall separateness and fairness. The KC decision connects directly to the principles we saw in earlier episodes. Remember how undercapitalization in Walkowski v. Carlton left accident victims with minimal recovery from William Carlton's taxi corporation? The same issue appeared in KC. The LLC's lack of assets mirrored those judgment-proof taxi corporations, and both were designed to limit recovery for tort victims. And like the asset stripping behavior in Land Services v. Peppersource, where Marchese systematically drained corporate assets to avoid creditors, Flahive's empty LLC served a similar function of placing foreseeable environmental risk on a property owner instead of the operator. This repetition across cases and entity types underscores a key point. Courts look for patterns where the entity's form is used not for legitimate business, but to evade responsibility. But LLCs do have some unique characteristics that create different risks and opportunities compared to corporations. So let's explore how the LLC structure both mirrors and diverges from what we've learned about corporate veil piercing in our previous episodes. So first, let's talk about legal framework. LLCs are governed by state LLC statutes, with many states adopting a variation of the Uniform Limited Liability Company Act, or ULLCA. Section 304 of that act provides that members and managers aren't personally liable for LLC debts solely by reason of being members or managers. This creates the same basic liability shield that corporate shareholders enjoy under statutes like the Delaware General Corporation Law. But the language and structure are different. One key difference is in management structure and formality requirements. Remember from our episode on corporations how important it was for directors to follow formalities like holding meetings, keeping minutes, and maintaining proper records. Corporations have rigid statutory requirements for governance and have to do these things. And the Model Business Corporations Act and the Delaware General Corporation Law basically say you have to have these type of meetings. But LLCs, by contrast, are designed to be more flexible. You don't have to hold annual meetings. You don't have to maintain extensive minutes. And you don't have to have the same formalities that corporations do. This flexibility is one of the main reasons businesses choose the LLC form. It allows for more informal operation while still providing liability protection. Many small businesses find that corporate formality requirements are overly burdensome, and they prefer the LLC's streamlined approach. But this flexibility can also create unique risks for LLC owners. Because LLCs don't have to follow strict formalities, it's easier for owners to slip into patterns that blur the line between the entity and themselves. When there are fewer structural requirements to maintain separation, owners might have to be more intentional about preserving that separateness on their own. Unlike corporate directors who have statutory meeting requirements that force periodic consideration of entity separation, LLC members have to create their own discipline. And this is particularly true for single-member LLCs, which have become incredibly popular, but face heightened veil-piercing risks. Just think about the dynamics. If you're the sole owner of an LLC, there's no board of directors to provide oversight, no other members to create natural checks and balances, and no formal structures requiring you to treat the LLC as separate from yourself. It might feel even weird to hold meetings with just you in the room. And these very characteristics that make LLCs attractive for single members also create conditions that courts can view with suspicion. Single-member LLCs face what I would call a presumption of unity problem. When one person owns and controls everything and doesn't follow formalities, courts would naturally be more skeptical about whether true entity separateness exists. The factors we discussed in previous episodes, like commingling funds, using business assets for personal purposes, failing to maintain separate records, they become even more problematic in single member contexts because there are fewer natural barriers preventing these behaviors. And this connects back directly to Kaycee, where Flahive's complete control as managing member made it easier for the court to question the LLC's separateness. Without other members or formal governance, single member LLCs have to work harder to demonstrate independence, like maintaining detailed records of business decisions and transactions. The environmental contamination in Kaycee Land and Livestock v. Flahive illustrates another important point about LLC liability that connects to our earlier discussions. Environmental damage often creates the kind of involuntary creditor situation that makes courts more sympathetic to veil-piercing arguments. Multi-member LLCs face different but related risks. While they have more natural separation between ownership and control because of multiple stakeholders, they also face potential conflicts about management and decision-making that can lead to behavior that courts view as problematic. If members treat the LLC as a partnership and ignore entity formalities, or if some members dominate others in ways that suggest alter ego behavior, veil piercing becomes a real possibility there too. The operating agreement plays a crucial role in the LLC veil piercing analysis. Unlike corporate bylaws, which largely govern internal procedures within a standardized corporate framework, LLC operating agreements can fundamentally reshape the rights, duties, and relationships among members. A well-drafted operating agreement can provide strong evidence that members intended to maintain entity separateness, so long as they follow it. But if you have an operating agreement you ignore, it shows the opposite. So while an operating agreement can establish protocols for decision-making, it's crucial that you actually follow those protocols. And a poorly drafted operating agreement, or worse, the absence of any operating agreement at all, or maybe one you took off LegalZoom, can suggest that members didn't take the entity seriously. Courts may infer from the lack of formal documentation that the LLC was intended as a piggy bank or just a pass-through for the members' personal activities. Let's also consider how LLC taxation affects veil-piercing analysis in ways that don't apply to traditional C corporations. Most LLCs elect pass-through taxation under Subchapter K of the Internal Revenue Code, meaning the entity doesn't pay corporate income tax. Instead, profits and losses pass through the members' personal tax returns. They get a K-1, similar to partnership taxation. This tax treatment doesn't itself create a veil-piercing risk, but it can contribute to a pattern where members treat the LLC merely as a pass-through for their personal activities, rather than treating it as a separate business entity with its own economic substance. Courts have adapted the traditional veil-piercing factors to account for LLC characteristics while maintaining the same underlying principles, and that's what the Kaycee court made clear. The same two-part test applies. First, is there such unity of interest and ownership that the separate personality of the entity is just a fiction? Second, would adhering to that fiction be a sanction of fraud or promoting of injustice? Because when those two factors are met, courts may pierce. But courts recognize that some traditional corporate factors need adjustment for LLCs too. For example, failure to hold regular meetings or maintain corporate minutes carries far less weight in the LLC analysis because they're not required for LLCs. So courts have to focus more heavily on factors like adequate capitalization, maintaining separate bank accounts, documenting business decisions, and avoiding commingling of business and personal assets. This adaptation is evident in Kaycee's remand, where the court instructed the trial court to apply corporate veil-piercing factors while accounting for LLC differences. The rise of series LLCs in some states adds another layer of complexity to modern LLC veil-piercing analysis. In a handful of states, series LLCs allow for entity separation within a single LLC form. Each is supposed to have separate assets, separate members, and liability shields, and it's designed so that we have liability shields between two pieces of property that would otherwise need to have a complicated entity structure. But while the series LLC structure can provide additional protection by segregating risk, it creates new opportunities for abuse if the series aren't properly maintained as separate units. Courts are still developing approaches to series LLC veil piercing, but I imagine the same principles of genuine separateness would apply here too. Looking ahead, the LLC veil piercing law continues to evolve as courts encounter new fact patterns and new business structures, and in fact, new types of LLCs. I haven't even scratched the surface of LLCs governed by decentralized autonomous organizations because there's no case law on that yet. But the basic principle should hold. LLCs should be pierced when there is no distinction between the owner and the purported entity, and when there is harm to another person. So, as we wrap up today's exploration of LLC veil piercing, remember that fundamental principles remain consistent across entity types. Courts are looking for evidence of genuine separateness and legitimate business purpose. When entities are used as shields for abuse, or when owners ignore entity boundaries, courts may step in to prevent injustice, regardless of whether the entity is nominally a corporation or an LLC. The choice of business form doesn't change the underlying obligation to respect formalities and separateness that make limited liability possible and valuable. In our next episode, we'll explore some of the more advanced variations of veil piercing doctrine that push these concepts even further. We'll examine reverse piercing, where owners or creditors try to reach entity assets. But for now, let's wrap up with some key takeaways. First, LLCs can be pierced, and courts will use adapted corporate principles. The flexibility of LLCs might actually increase risks because without the governance that is required in corporations, single member setups in particular might engage in commingling. Operating agreements are crucial for proving separateness, but of course they have to be followed. And we'll talk about some other advanced topics in our future episodes. But until then, I thank you for joining me. I'm Professor Seth C. Oranburg, and this has been Organized.